Look, I'm George Conway, and I need to tell you something that should terrify every American who cares about the rule of law. Last week, I got my hands on one of Trump's internal legal strategy documents, not through some dramatic leak, but because his lawyers filed it as part of a routine Supreme Court motion in one of the 400 plus lawsuits currently pending against his administration. And what I read there confirms everything I've been warning about for months. This isn't incompetence. This isn't chaos. This is a deliberate, systematic strategy to dismantle judicial authority in America. The brief I'm talking about was filed March 14th, 2025, in response to the birthright citizenship cases working their way through federal courts. 4 federal judges have temporarily blocked Trump's executive order attempting to end birthright citizenship for children born in the U.S. to parents who are not in the country lawfully. That's 4 different judges appointed by Democrats and Republicans all saying the same thing. This order violates the 14th Amendment. It's not close. It's not ambiguous. The Constitution says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. Period. End of sentence. Trump doesn't get to rewrite the Constitution with an executive order, but here's what Trump's lawyers argue in this brief. And I want you to understand how dangerous this is. They claim that district court orders that currently apply nationwide should be narrowed to allow the administration to begin implementing its new policy challenging birthright citizenship. Read that again. They're not saying the judges got the law wrong. They're saying that even if judges rule against them, those rulings shouldn't apply everywhere. They want to implement an unconstitutional policy in some places while the legal fight continues. That's not how injunctions work. That's not how the law works. But that's the strategy. Ignore judicial orders, claim they're too broad, and keep doing what you want until someone physically stops you. Now, you might be thinking, George, this is just aggressive lawyering. Every administration pushes boundaries. No, this is different. Trump is facing roughly 400 lawsuits resulting from his executive orders, far more than had been filed at this point during his first term. 400. In his first 6 months back in office, Trump has generated more legal challenges than most presidents face in 4 years. And here's the pattern that emerges when you read these briefs. In virtually every case, Trump's legal team makes the same core arguments. First argument. The president has inherent Article 2 authority to do basically whatever he wants, and Congress and courts can't stop him. You see this in the birthright citizenship brief. You see it in briefs defending his mass firing of federal workers. You see it in his attempts to control independent agencies. The legal theory is called the unitary executive, and it's been around for decades. But Trump takes it to an extreme that would make even conservative legal scholars blush. He genuinely believes, and his lawyers argue in court, that Article 2 of the Constitution gives him dictatorial powers over the executive branch and anything touching executive functions. Second argument, when judges rule against him, those rulings are either judicial activism that exceeds judicial authority, or they're procedurally flawed because they apply too broadly. White House Press Secretary Caroline Leavitt said, "We believe these judges are acting as judicial activists rather than honest arbiters of the law, arguing that the real constitutional crisis is taking place within our judicial branch." This is gaslighting on a constitutional scale. Judges following the Constitution and statutory law aren't activists, they're doing their jobs. But by calling them activists, Trump creates a narrative where disobeying court orders becomes defending the Constitution rather than violating it. Third argument, even when he loses in court, implementation should be allowed to continue during appeals. This is the most insidious part. Normal procedure is you issue an executive order, someone sues, a judge issues a preliminary injunction blocking the order while the case proceeds, and you stop doing the thing until the case is decided. Trump's team argues that because the issues are important or time sensitive or affect national security, judges shouldn't be allowed to stop him even temporarily. It's a heads I win, tails you lose approach. If he wins eventually, great. If he loses, well, he's already implemented the policy for months or years, and you can't undeport someone or unfire someone or unfreeze funding. Let me show you how this plays out in practice with real examples. On the 13th of February 2025, a federal judge, U.S. District Judge Leo Sorokin in Boston, issued a nationwide preliminary injunction blocking President Trump's executive order that sought to end birthright citizenship. Clear ruling. Constitutional basis. What did Trump do? His administration immediately appealed and filed emergency motions with the Supreme Court asking to narrow the injunction. They didn't comply and then appeal. They appealed while continuing to fight compliance. Or look at the Doge firings. On the 13th of March 2025, U.S. District Judge William Alsup of the Northern District of California issued a preliminary injunction directing 6 federal agencies to reinstate roughly 16,000 probationary employees. Judge Alsup ruled that their mass firings were unlawful and carried out without following required procedures, calling the process a sham. 16,000 federal workers fired illegally. Judge says reinstate them. Does Trump reinstate them? No. He appeals to the Supreme Court, and a recent 7-2 ruling by the Supreme Court paused the rehiring of the 16,000 probationary employees. So now those workers are still fired, even though a district court said their firings were illegal because Trump ran to a friendly Supreme Court that gave him a temporary stay. This is the strategy. Flood the system with so many unconstitutional actions that courts can't keep up. When you lose in district court, which Trump does constantly immediately appeal and ask the Supreme Court to stay the lower court ruling. Since the Supreme Court now has a 6-3 conservative majority that includes 3 justices Trump appointed, he's betting they'll either grant stays or rule in his favor eventually. And even if they don't, the delays mean he gets months or years of implementing illegal policies before anyone can stop him. But here's what really exposes the strategy. Trump's lawyers aren't even pretending to respect judicial independence anymore. Attorney General Pam Bondi said during a Wednesday news conference that judicial impeachments are not going to happen right now. Meaning, we've considered impeaching judges who rule against us. We've decided not to do it yet, but we're leaving that option on the table. Trump himself has called for Judge James Boasberg to be impeached after Boasberg blocked his use of the Alien Enemies Act. Chief Justice John Roberts, a really conservative member of the Supreme Court's right-wing majority, of all people, had to weigh in and call his comments inappropriate. When John Roberts thinks you've gone too far in attacking judicial independence, you've gone too far. And then there's the law firm strategy, which is even more chilling. Trump issued executive orders targeting major law firms' security clearances and government facilities. If such orders stand, they would call the survival of the firms into question, since they would create enormous logistical problems for any client that had a case involving the government. Think about what that means. Trump is saying, if your law firm represents people suing me or people I don't like, I will destroy your law firm by making it impossible for you to represent any client who needs government clearances or access to federal buildings. That's not just retaliation against lawyers. That's eliminating the ability of citizens to find counsel willing to challenge the government. Paul, Weiss, Rifkind, Wharton, and Garrison was targeted on the 14th of March 2025 and faced retaliatory sanctions due to its pro bono work and associations with individuals involved in investigations against President Trump. The executive order was rescinded after the firm agreed to provide $40 million in pro bono legal services aligned with the administration's agenda and to discontinue its diversity policies. Let me translate that. Trump said, I'll destroy your firm unless you give me $40 million in free legal services and abandon your commitment to diversity. And the firm caved. Conservative lawyer George Conway called it the most disgraceful action by a major law firm in my lifetime, and he's right. But can you blame them? If you're a law firm with thousands of employees and clients who depend on you, and the President of the United States credibly threatens to end your existence, what do? That's the strategy. It's not subtle. It's not hidden. It's right there in the legal briefs and executive orders and public statements. The strategy is claim unlimited executive power, attack judges who disagree, delay compliance with adverse rulings, intimidate lawyers who might challenge you, and flood the system with so many violations that people get exhausted trying to fight them all. As Conway said on February 13, this administration is essentially run by sociopaths, by psychopaths. Sociopaths do not follow rules. They think they are above rules. They think they make the rules. They are arbitrary and capricious. And this is where we are now. I don't say that lightly. I was a Republican my whole life. I worked at one of the best law firms in America for 3 decades. I understand how government is supposed to work, how courts are supposed to function, how executive power is supposed to be constrained. What Trump is doing isn't conservatism. It isn't even authoritarianism in the traditional sense. It's nihilism. It's the belief that power justifies itself, that rules are for other people, that winning is the only thing that matters. And the legal briefs written by lawyers who went to good schools and clerked for respected judges give that nihilism a veneer of respectability. Chapter 1. And I've only scratched the surface. The next 2 chapters will show you how this strategy plays out across different areas of law, and what happens when an entire branch of government decides it doesn't have to listen to the other two. This isn't a constitutional crisis. A crisis implies something temporary, something that might resolve itself. This is a constitutional collapse, and it's happening in slow motion, one legal brief at a time, while most Americans aren't paying attention because it's boring and technical and involves words like preliminary injunction and administrative stay. But boring and technical is how democracies die, not with jackboots, but with legal memos.